A few cases, my lord. In this case, my lord, on senior counsel Rajendra Nagar is arguing counsel, my lord.
Mr. We don't pass over in summer vacation. We don't pass over.
Few cases के लिए हुजूर किया
Not
जा-
even for a minute.
ले है हुजूर.
Sorry. Yes.
Yes, my lord. Lord, case is initially instituted under section 307 and other sections, subsequently 302 added. Petitioner is in custody since 6/8/2020.
No, just a minute. Let
Yes.
us see the FIR.
Yes, my lords. The FIR, my lords, may have.
Your name
Lords,
in the FIR.
along with 9 persons, not 8 other persons, my name
Vijay
also
Kumar
features.
Sinha.
Yes, my lords.
Read the FIR.
यस मिनट निवेदन पूर्वक कहना है कि मैं सुनीता देवी उम्र 100 गया की निवासी हूं। आज दिनांक 9/2/2020 समय करीब 8:45 बजे सुबह मैं अपने घर में खाना बना रही थी। उसी समय मेरे दरवाजा पर विजय कुमार पेटिशनर 60 इयर्स एज उर्फ किरानी जी, ललन कुमार शाही हु हैज बीन ग्रांटेड बेल बाय दिस ऑनरेबल कोर्ट, विपिन कुमार, भुवनेश्वर प्रसाद ऑल्सो ग्रांटेड बेल, सत्येंद्र कुमार, फरेश यादव, बोनू, लालू यादव, सभी लोग मिलकर मेरे दरवाजा पर चढ़कर गाली गलौज एवं इज्जत लूटने का प्रयास किया और मुझे मारपीट कर रहा था। जब मैं चिल्लाई तो मेरे परिवार के लोग जुटे। उसी बीच उपरोक्त सभी लोग मिलकर मुझे एवं मेरे परिवार के लोगों को लाठी डंडा एवं रॉड से मारपीट कर जख्मी कर दिया और मेरा ब्लाउज पहने हुए सारी बुरी नियत से फाड़ दिया और वे सभी लोग मारपीट करने के बाद 4 फायरिंग किया जो किसी को नहीं लगा। दिस इज द इनिशियल FIR, lords. My name has been taken along with 8 others with a general and omnibus allegation, out of whom, Lord, 2 persons have already been enlarged on bail. Subsequently,
just a minute.
Yes,
Who died?
Yes, my lord. My lord may now come to Annexure 4. Subsequently, during course of investigation, another Fardbayan has come to be lodged at page number 19.
Yes.
Yes, my lords. Now, my lords, on this in this FIR, Lord, entire different version of the prosecution
Now,
comes
this FIR is by whom?
by Vinod Bihari.
So this is
a Fardbayan recorded during course of investigation.
That's right. So therefore, this is part of the
Yes,
FIR.
yes.
This is part of the FIR of Bathani PS case
My
number
lords,
15
my
or
lords,
20, which
my
you
lords.
read. So
Right,
this will be
right.
taken as a statement under section 161.
Under 161. Yes, my lords.
All
under
right, then.
Yes, my lords. So now in this Fardbayan.
And who is this person? Vinod Bihari?
Vinod Bihari is a person, lords, whose son has died. Whose son has died. Rishi Kumar.
Who was this Sunita Devi?
Sunita Devi is somehow related to this. The relationship
All
is
right.
not very clear, but related to this family.
All right.
Lords, and here, my lords, a different story comes, my lord, that when मेरा मृतक भतीजा Rishi Kumar, the informant, the Fardbayan has been lodged by Vinod Bihari, who is the uncle of Rishi Kumar. उम्र लगभग 21 वर्ष, बयान दे रहा हूँ कि 9/2/2020 the same day को समय 8:45 बजे मेरा भतीजा ऋषि कुमार पैदल गया जाने वाले रास्ते पर जा रहा था। पहुंचे मेरा छोटा भाई उपेंद्र प्रसाद जा रहा था तो रास्ते में राजीव प्रसाद इज द हस्बैंड ऑफ सुनीता देवी, दैट आई मे क्लैरिफाई। राजीव प्रसाद के घर पर विजय कुमार सिन्हा एंड ऑल दीज पर्संस हैव बीन नेम्ड, लॉर्ड्स, द 9 accused persons, सभी लोग आए और गाली गलौज कर रहे थे तथा विजय कुमार सिन्हा सुनीता।
Let us see the order of bail.
Yes, my lords, I'm just passing it over. Both. It's a detailed order, my lords. There's a case and counter case. Annexure 2 is the counter case by the petitioner side also.
You're in custody since when?
6/8/2020.
6/8/2020. So that makes it more than 1 year.
Lordships.
And what is the stage of the case?
Lords, I'm informed that probably charge has been framed. Charges have been
Trial
framed.
has been started, my lord.
How many witnesses have been examined?
One witness has been examined, my lord. Tomorrow, my lord, second witness is going to examine, my lord. Out of 5 witnesses, my lord.
Ask your senior to be here. We are passing it over.
My lord.
Ask him to be here because prima facie I'm inclined to grant bail. So therefore, let you not feel that your senior has not addressed. Here is come. Yes, Mr. Narayan, I had refused.
I'm very sorry, my lord.
Not at all. I had refused adjournment of Passover only on the ground that during summer vacation we don't entertain such prayers.
Lordship.
You come on the call. If not, go after vacation.
Your lordship, sure, perfectly
Or
right.
maybe because of you or somebody else, All such orders where I have asked the cases to be listed after vacation, that order I have recalled and it has been passed over. So, but no passover for few cases. Yes, now since I was inclined to grant bail, therefore I thought that I must hear you.
Lordship, only two things I want to point
Yes.
out, Lordship. I know she might have placed one thing that earlier one co-accused has been granted bail.
Yes. Which is weighing very heavily.
Lordships, I know, because in that case also I had appeared. Now here two situations are there. Firstly, my lords, the trial has already begun.
Yes.
And out of 5 witnesses, one had already been examined, one is being examined today. He is on the dock. And out of the remaining 3, 2 are officials. So it will be completed hardly within a month or
but
2.
that's all right.
Second aspect, my lord. He is a known proclaimed absconder.
One thing at a time. One thing at a time, Mr. Narayan. Now, with respect to this argument, if similarly situated person has been directed to be released on bail only recently, I mean not say a year ago, and the trial is trial has begun and some of the witnesses have been examined, can that be a ground to hold him back? Now, you can expect an order from the court directing him that if he doesn't appear on 2 consecutive occasions before the trial court without proper permission, the bail would be cancelled. So that's one thing. Now, second, what you're talking about, absconder.
My lords.
Is he a proclaimed absconder?
Lords,
Then I don't grant anticipatory bail.
Exactly.
No, there is no
Just
bar
today-
for grant of bail because
Just today in the
Just a
newspaper.
minute.
Just a minute.
one at a time.
My lord.
Now, what is the purpose of proclamation?
My lords, this is a
For
case of
the
19
production, so that he comes. The moment a person comes, say a second before the order or proclamation is to be made, if the accused person surrenders, what happens? He is not an offender. He is not a proclaimed offender. He remains an offender. He is within the dragnet of law.
It's a matter of 1991.
That's all right.
And
So therefore, that bar of Madhya Pradesh High Court judgment and of Supreme Court judgment, there is nothing in the CRPC that is relatable to any discretion while granting anticipatory bail. You are aware of that?
with this, my lords, I was linking the second aspect that in paragraph 3, I find mention only of 3 cases, and in 2 very intelligently it has been drafted. We are unaware of the remaining 2 cases. 1 is given. Apart from these 3, there is a 4th one in which it is a case of 1991 and the accused is an absconder. Therefore, I was submitting.
Yes.
That is
Lords,
the concern.
Lords, my
How
pa-
can he be an absconder in a case of 1991
This is
when
what-
when he is in custody since 2020?
And we have brought it to the notice of the district officials there.
No. Therefore, there is some mismatch in the information. See,
Anyways, they have not even refuted because we
See-
have brought it on record
see,
in
there is
supplementary
the-
affidavit.
the bringing the offenders to the book, concluding the trial against erring persons. These are the basic job of a criminal justice dispensation system. But there is something above it. Now, we can't make distinction between 2 accused persons with similar accusation.
Lord Secretary,
And that also when he has remained in jail for about 1.5 years.
that period is
And it will be difficult for me to justify the detention.
the best course, if I may submit like, and if the honorable court chooses like that, a report may be called for so that by what time, if it is likely to be concluded within 2 months.
Even if it is likely to be concluded tomorrow, in a consideration where the other person has been granted bail only recently, and only because in the interregnum trial has begun. I mean, I don't see
Then
any
I-
justification as a judge.
Then I will not come in the way, my lord.
If these persons would not have been granted bail and the trial would have begun, we would have surely asked for the report. Now, assuming report is the trial shall be concluded without any delay, but what justification does this court have to hold it back?
Then the
This is not giving due deference to the court which has passed an order, number 1, and number 2, making illusory distinction between 2 accused persons.
Lords, I bow down to your lordship. So
That's
then
all right. That's
then the
all right.
condition that the honorable court was just now saying that if he is...
Surely.
Yes.
Heard MS Soni Srivastava, but we are absolutely happy in hearing Mr. Narayan opposing a bail where the court right from the beginning was inclined to grant bail. But then you have made the court think. That's a good purpose of a senior advocate. You heard about Soni Srivastav, learned advocate for the petitioner, and Mr. Rajendra Narayan, learned senior advocate for the informant. The state is represented by so-and-so. The petitioner seeks bail in connection with sessions trial number so-and-so arising out of PS case number so-and-so, in which he has remained in custody since
6/8/2020.
6/8/2020. According to the first information report, petitioner and 7 others are said to have taken part in the assault, which ultimately led to the death of the deceased. During the course of investigation, the uncle of the deceased, who also lodged a fardyan, which has become part of the record of the subject FIR, has narrated another story in which the act of assault on the deceased is attributed to somebody else in a different transaction and with a completely different connotation. The statement of the uncle of the deceased discloses that the subject FIR is motivated and only for the purposes of shielding the real accused persons. Be that as it may, considering the general and omnibus nature of accusation against 2 of the other accused persons whose case stands on exactly similar footing, 2 benches of this court have granted bail to them by orders dated 22/11/2021 and 24/2/2022, passed in criminal miscellaneous number 16602 of 2021 and 21600 of 2021 respectively. While opposing the grant of bail to the petitioner, Mr. Narayan Leonard, senior advocate, has contended that after the 2 orders in the aforesaid application with respect to other co-accused persons was passed by different benches of this court, trial commenced, and now 2 witnesses have already been examined out of 5, and 2 are only official witnesses. Thus, for all practical purposes, it can safely be predicted that the trial shall be concluded in near future. In that event, there would be no necessity of directing for release of the petitioner, who has been named in the FIR as one of the participants in the occurrence. He has further submitted that the declaration of the petitioner regarding his criminal antecedents is too vague to be accepted. According to his information, in one of the cases in which the petitioner was made accused earlier, the case is of the year 1991, where he has been declared an absconder. In the present case also, there was an absconder. An absconder. M.S. Srivastav, learned advocate for the petitioner, in response to the aforesaid objection, has submitted that the information provided by the informant is fallacious, as once the petitioner was in custody for more than 1.5 years, there was no reason for continuing with declaring the petitioner an absconder in another case, even though it was registered in the year 1991. Be that as it may, regard being had to the aforenoted facts, especially taking into account the period of custody of the petitioner, which is from so-and-so date 6/8/2020, and the trial not having been concluded up till now, the petitioner is directed to be released on bail on his furnishing bonds in the sum of rupees 10,000, 2 sureties of like amount, to the satisfaction of the trial court. However, it is cautioned that if the petitioner does not participate in the trial proceedings on 2 consecutive occasions without taking the leave of the trial court, it shall be open for the trial court or the investigator or the informant to move necessary application before the court below for cancellation of the bail granted to the petitioner. In that event, the trial court shall promptly proceed in that direction.